Good morning, David. As I think we discussed earlier this morning, I'm going to try and run through about a dozen questions, and then maybe there'll be a chance for questions from the floor to cover the gaps in what I've asked about. One of the things that struck me as soon as I opened your report when it was published was in the start of the third paragraph. You said, "No one we spoke to recommended radical change." Did this surprise you? Do you think it's a characteristic of the industry that everybody wants to sort of move in a very steady manner forward? That to a certain extent ties in with what Regina's just been saying about the lack of willingness to embrace innovation.
It didn't surprise me in the sense of responses from the people in the industry, from the companies. I was, I suppose, surprised, no offence meant to the companies, but it didn't surprise me. I was slightly surprised that there wasn't more call for radical change from outside the immediate sector. But in fact, most of the people we talked to said, actually, it works well, we just need it to work better. The system is right, we need Ofwat to do more of this or more of that or whatever. And slightly disappointingly, a lot of those responses were very much in command and control mode. Going back to the previous conversation, it was Ofwat must tell the companies to do more or whatever. Mm-hmm. The idea that you might have a completely different approach didn't really come up that much at all. The most radical thinking actually is in some of the Ofwat documents.
Interesting. Yeah. We just heard Richard Benyon talk about the importance of clarity and objectives, and that's a phrase that you use as well in your report on a number of occasions, and also this, the importance of desired policy outcomes. But is there not an issue here about the independence of regulators relative to politicians? Because economic regulators sort of provide a degree of detachment from the politicians, and thus a protection from some of the uncomfortable decisions. And we can see that particularly, for example, in the way at the moment DEC is deflecting issues onto Ofgem about energy bills and so on. Also, regulators, for their own sort of sanity, probably don't want to be too corralled by politicians. Do you think the White Paper is going to strike the right balance here?
I can't answer the last question because I don't know what it's going to do, but I think I don't think independence is a concern in the context of clarity. You need clarity of government objectives and policy in order to protect the independence of the regulator, I think. At one level, the call for clarity could simply be to get a response from government that says, this has nothing to do with us. This sector seems to work perfectly well. It has regulators, it has companies, etc. We are not going to interfere. But that's not the impression that's been given in recent years. The government clearly has interests in policy. It has an agenda. And I think that the participants in the sector need to know what that is in order to behave sensibly. I mean, at its simplest, if you take the example of competition, which people most regularly called for clarity, what is the policy, who's in charge, etc. You could say there's a default position here, which is that the regulator has a competition duty. We're happy with that. That's been the position since privatisation, certainly since the 2003 Act. I'm not saying that the government should tell the regulator what to do or should infringe its independence at all. I'm just saying it'd be very helpful if it was clear exactly what the government does want and then how the various actors in the sector are meant to behave within that.
There's been a number of mentions earlier about the regulatory burden, and obviously, as Regina has announced, removing the June returns is a very simple exercise in removing the regulatory burden. And the infamous June returns, however, did, in some ways, to my mind at least, play a role in risk management within the companies. And is there not a risk that if companies collect less data with less frequency, that at some stage some of them won't have the necessary risk management regimes in place, and that we will find in, say, 3-5 years' time that perhaps under the maligned ancient regime, these events might have been prevented?
Well, I mean, you would certainly hope it's not a danger. Companies should be undertaking their own risk management and then reporting quite separately to the regulator. In fact, one of the questions I asked each of the companies I met was, what would you do if the June return was abolished? And that was not with any foreknowledge of what was coming. It was just a thought experiment. How much of this information would you actually collect? And the answers were quite interesting. It ran from, well, not very much of it to almost all of it, because we need it. But on the other hand, we would collect it less often, less rigorously, because it doesn't need to be that accurate, etc. Companies were thinking about what they needed to run their business, and they will even more so have to think about it, and in the new regime as proposed. So that I would say is a good thing. Companies should collect the data they need to run their business. Ofwat should collect the data they need to set a price control and to establish whether the companies are meeting their obligations. And that may require them to impose some things on companies that they wouldn't otherwise collect. But I'd be surprised if there was much inconsistency between the two data sets, really.
Mm-hmm. You mentioned just then the lesser degree of accuracy and less frequency about the data that might be collected in the future. Isn't there a danger that data which is perhaps collected with less precision and on a more infrequent time scale, perhaps much less useful? Is there not a danger that what will be collected in the future might not serve its purpose? Or do you think the intensity of collection has been too great?
I think the danger is either that as the regulator you finish up without the necessary data to run an efficient price control review, or that you finish up without the necessary data to establish whether a company is meeting its obligations properly or not. Mm-hmm. And what you mustn't do is risk the availability of that data. And an annual return is one perfectly sensible way of doing it. It means everybody focuses on the data once a year, and there's a sort of running series of facts and figures for the regulator next time they look at a price control. So it's a perfectly sensible way of doing it. The problem in the water sector was that it had got completely out of scale with those two tasks of setting a price control and monitoring obligations. It's not the only way to do it, though, either. You can, if you're moving towards risk-based regulation, then you need much more to know about how the companies are performing, whether their networks are working properly, etc. It's a different set of data. So the risk is just that the requirement is to make sure you don't fall into the trap of not having the data you actually need, mm-hmm. as opposed to just collecting masses on the basis that you'll be able to look at it later.
In your report, you talk about, and I think it was also alluded to in what Regina was saying earlier, that much was made of the burden of the sign-off of the June return by the board. But surely that's no different from directors signing off annual accounts. And wasn't this to a certain extent a governance cop-out? Because if you're a director of a PLC or the regulated utility beneath it, you earn a premium salary, you take responsibilities, and one of those is risk management. And if something goes wrong, you're in the frame.
It's a question of degree, I think. If you're on the board of a private sector company and you're on the risk committee or the audit committee, your responsibility is to make sure that the systems are there to put you in a place to make sensible strategic decisions about the running of the company. Water company directors absolutely have to do that. Mm-hmm. The problem was, because of the sheer focus on detailed monitoring and intervention by Ofwat, boards were feeling, I think, that they had to sign off these statements to a much greater degree of veracity of the data. Mm-hmm. Are we really sure that everybody in-house has done their job absolutely properly, as opposed to, do we have systems that we think are robust and we're judged on them if they go wrong? That's a different approach.
I'd like to move to sort of the CapEx regime and particularly sort of go back to one point which I think most people would, if not everybody, agreed with your conclusion that the new incentive regime, the CIS at PR09, wasn't the final sort of fully polished article. But from your off-gem days, there the incentive regime had to be fine-tuned as well. Is it not the case that whilst yes, there was some confusion about the CIS, that having some kind of incentive regime is all part of passing some of the risk management onto companies?
Yeah, I think something like the CIS is a good thing. I don't think it's intrinsically complicated. I still don't think that I quite understand what went wrong, because I don't think it worked properly in this sector. It seems to have been understood and adopted by energy companies and the energy regulator without any of the confusion that happened in water. So I honestly don't quite know what happened. I was speculating at another conference whether it reflected on the relative intelligence of water companies and electricity network companies, but I couldn't really believe that was the case. It's something to do with the clarity of what you're trying to do with it. I don't think that Ofwat had really made clear what it was for, or that the companies had seen it as an opportunity to get the plan they needed approved, or to get a slightly different one approved, but at some cost. I think that kind of incentive is important, and I would actually hope that Ofwat continues with something like it.
Regina, when she was talking earlier, talked about moving to TOTEX in terms of a way of getting away from the capex bias. Do you think this is the way for the water industry to achieve the desired symmetry in terms of incentives?
Yes, I think it is. As a regulator, dealing with the asymmetry of incentive strengths between operating expenditure and capital expenditure is a really difficult thing to do. And it is impossible if you try to do it in the context of statutory accounts or regulation accounts where you have the clear distinction between capex and opex for obvious reasons. We struggled for years at Ofgem to come up with ways of effectively equalising the strength of the incentives, and failed. And I see that Ofgem has taken the logical next step of saying, okay, we'll abolish that distinction, treat it all as one thing. What you lose is the link between the physical assets in the system and the regulatory asset value, because there can no longer be a straight linkage between the two through the depreciation mechanism and so on. But that strikes me as being a relatively small price to pay for a system which removes the distortions that I definitely see from the capex-opex bias. I notice Regina and all her colleagues call it the perceived bias. I've been through the same discussions with economists. They tell me that actually it's not real, but it's certainly there. You can see it operating. Whether it's perceived or actual or not, I don't mind. It's unhelpful, and it would be a good idea to deal with it.
You acknowledged in your report that the whole issue of renewables and the extent to which the water companies should be investing in renewables alongside their operations is a tricky one, and you endorsed Ofwat's stance. This puts you somewhat at odds with the approach of the Scottish Government, which talks about creating a hydro nation. Do you think that there's some middle ground? Some of the companies are much more enthusiastic on developing a renewables capability than others.
I found it disappointing that the companies that were enthusiastic didn't feel able to do it. I mean, that's partly wearing my old energy regulator's hat as much as an Ofwat reviewer, because the regime is meant to make it feasible to develop small-scale renewables, and it seems to work pretty well outside of the water sector. And that was one of the things that made me think about how much it's the Ofwat relationship that drives what companies do. I couldn't understand why more of them, faced with the logic of on-site renewable generation, weren't doing it. And it was simply because it didn't necessarily go into the regulatory asset value, and therefore they didn't necessarily make money out of it. And that's a very defensive, non-innovative approach. Now, you could take the Scottish approach is perfectly sensible. It says this is important. Let's make it part of the functions of a company to introduce renewable generation. That's not how the English and Welsh system is currently set up. But one of the things that I suggested a degree of clarity from government on was their interpretation of what is the core business of the water company in that sense. And you could interpret it, or you could change the statute to make it include on-site generation. You could go that way. You could go the other way. What I was saying about Ofwat's approach is that it struck me as perfectly consistent with the duties and obligations of the companies to treat it in the way they did. I just thought it was very strange that outside of that system, the companies didn't feel able to do more entrepreneurial things themselves.
When Regina referred to the Panorama programme, she mentioned the issue of leakage, particularly here in the southeast. You do discuss leakage in your report, but you don't actually sort of I think, go the whole way, in the sense that you, personally, I would criticise Ofwat's stance in not toughening the leakage targets at PR09, particularly in the southeast, because that is one way to encourage companies to invest more in their networks. Now, maybe it was this old balancing act of trying to keep the charges at a particular level without too much more on infrastructure renewals. But there is a trade, and there's definitely a trade-off there. But it does seem to me counterintuitive that on the one hand, all regulators, not just Ofwat, but particularly the Environment Agency and the Drinking Water Inspectorate, are concerned about this issue of the amount of water which doesn't get to the customer, yet we don't have targets at the moment which are any tighter than in the previous 5 years. And you ducked that one.
I wasn't actually asked to address it.
You discussed leakage, then you sort of leave it sort of hanging there in your report.
I think the difficulty here is there's a complicated underlying issue, which is in Ofwat's terminology, the economic level of leakage. Yeah. It is a cost-benefit assessment, and you need a framework to look at that cost benefit within. And I think one of the areas where, again, some clarity from government would be quite helpful is in their view of the importance of leakage reduction and therefore whether tests should be set on the cost benefit analysis. And I think there was a bit of confusion between the aspirational target of 130 litres or whatever, which was set out there as an objective in an aspirational sense. And it wasn't clear how that was meant to relate to what Ofwat did and what targets the companies were set. So to the extent that it came within our remit, I think my main observation was you need to be absolutely clear what you want the companies to do. And if you're sending different signals from government on the one hand and Ofwat its reviews, it's really, I quite sympathise with the companies if they fail to get it right in between all of that.
One final question from me. Your report advances some very clear recommendations for government, for Ofwat and for CC Water. And your report follows on from those of Martin Cave and Anna Walker, and various initiatives from Vince Cable about customer issues and so on as well. Do you think there's a degree of there being simply too many to-do items? Richard Benyon clearly has a lot of inputs now for the Water White Paper, and that some of the very valuable ideas that have been put forward, not least by yourself, will fall into the too difficult to do now tray when the Water White Paper comes out. And that's going to be a once in a decade opportunity in terms of updating the legislation and the direction of the industry.
I don't think it's a problem of there being too many to-do items. You'd be worried actually if there weren't enough, or if there weren't enough bright ideas around. I think what's needed now is real clarity as to which are important. It's prioritisation. What's important? And that probably needs to come from government. They need to say what their starting point is and what their objectives are. But then we need to get out of the process of the last few years where there's been a series of reviews and everybody's been concentrating on rethinking what should be done. And the industry needs to get into a period of getting on with it. So I think the important thing is to get some prioritisation into the government policy statement, into Ofwat's approach to regulation, and then let the industry get on with it, hopefully suitably incentivised.
Thank you very much.
Thank you.